judgment in the matter of Abbasi and another against Newcastle upon Tyne Hospital's NHS Foundation Trust and Haastrup against King's College Hospital NHS Foundation Trust.
When gravely ill children are being treated in hospital, disagreements sometimes arise between the parents and the clinicians treating the child as to whether life-sustaining treatment should continue to be provided. In circumstances of that kind, the NHS Trust may apply to the court for a declaration that it is in the best interests of the child that the treatment should be withdrawn. In some well-known cases in recent years, the reporting of proceedings of that kind resulted in the clinical team treating the child being vilified on social media and abuse being shouted at staff outside the hospital concerned. In order to guard against that problem, the practice has developed that NHS trusts, when they apply for a declaration of this kind, also apply for an injunction preventing disclosure by the parents or others of the identities of the hospital where the child is being treated and of the clinicians treating the child. These applications are not normally opposed by the parents or the media. Under current practice, such injunctions are granted for an indefinite period so that they continue to prevent disclosure of the identities of those involved unless and until someone successfully applies for the injunction to be varied or discharged. This appeal concerns the basis on which such injunctions can be granted, and in particular the basis on which they can be continued after the proceedings have ended with the death of the child. In the two cases under appeal, the court granted injunctions on the application of NHS trusts at the outset of the proceedings. The children died sometime afterwards, one of the children in 2018 and the other in 2019. Some considerable time after the children had died and the proceedings came to an end, the parents applied to be released from the injunctions. They wanted to be able to tell their story about what had happened to them and their child, and to be free to name and criticize the clinicians who had treated their child. The NHS trusts opposed the parents' applications, primarily on the ground that making public the clinicians' names would expose them to harassment and abuse. At first instance, the president of the family division held that the injunctions should be continued. The Court of Appeal disagreed and ordered that the injunction should be discharged, but stayed its order, in other words, suspended it, to allow time for an appeal to this court. The trusts now appeal to the Supreme Court, which continued the stay pending its decision of the appeal. The Supreme Court unanimously dismisses the appeal, but for reasons that differ from those given by the Court of Appeal. The Court holds that the High Court can grant an injunction of this kind on the application of an NHS trust where that is necessary to protect the child's interests or to protect the administration of justice. However, it cannot continue the injunction on that basis after the child has died and the proceedings have come to an end. So if the injunction is to be continued, it must be on some other basis. The High Court also has jurisdiction to issue injunctions in order to prevent interferences with NHS trusts' performance of their functions. However, that basis of jurisdiction has not been relied on in these proceedings, and the evidence does not in any event demonstrate any continuing risk to the trust's performance of their functions. The High Court also has jurisdiction to protect the rights of the clinicians themselves, not to be subjected to harassment and abuse. But those rights should be asserted in proceedings brought by the clinicians. The clinicians' rights cannot be asserted on their behalf by NHS trusts, at least in circumstances where there is no reason why they should not be asserted by the clinicians themselves, as is the position after the child has died and the immediate emergency has passed. The Court also observes that since the risk of harm to the clinicians is likely to decline after the proceedings have ended, a reasonable duration for an injunction will usually be until the end of the proceedings, and if they end with the child's death, for a subsequent cooling-off period. In the event that a continuation of the injunction is sought beyond the cooling-off period, the need for any continuing restriction of freedom of speech must be established convincingly. It was not established convincingly by the NHS trusts in these cases. The injunctions have remained in place until now because, as I explained earlier, this court granted a stay of the order made by the Court of Appeal. We have been asked by the NHS trusts to continue the stay for a further 21 days to allow time for the clinicians to seek advice about their position, but we declined to do so, as we can see no proper legal basis for us to impose any further restriction on freedom of speech in these cases.